Excellent. Thank you very much for that warm introduction. Thank you so much for the invitation and opportunity to present here. Thanks to all of you for coming along. Thanks to Zach for organizing my visit. This is my first time in Singapore, and it's an absolute pleasure to be here. I've been having the best time. So this is a paper, as James has mentioned, that is co-authored with Robert Mullins, who I've done some other work with. So I'm going to begin my presentation where the paper begins, which is with a bit of dystopian science fiction. So I'm going to ask you to imagine a world where humanity is all but extinct. A single person remains on Earth after a global collapse, and there's no hope for the continuation of human beings as a species. So can this person, the last human being, do wrong by destroying the natural world around them? So this is the question that Australian environmental philosopher Richard Sylvan poses in his famous Last Man argument. Sylvan asks us to imagine a scenario where the last man surviving the collapse of the world system lays about him, eliminating, as far as he can, every living thing, animal, or plant. So taking for granted that the last man has done something wrong, we're asked to explain why his actions are wrong. Now, for Sylvan, the answer ultimately lay in a rejection of human chauvinism in favor of an ecological normative ethic. But independent of his critique of anthropocentrism, Sylvan also maintained that the wrongfulness of the last man's actions could be explained in terms of the breach of a duty that is not owed to any person or thing as of right, which is to say, a duty that exists for reasons other than the interest that any person or thing has in the fulfillment of the duty. So the paper I'm presenting this evening tries to make sense of this kind of duty, understood as an intrinsic duty. So in brief, an intrinsic duty is a type of duty that's not derived from or justified by rights or by the interests of individuals. It's a concept from Joseph Raz, who first introduces it in a chapter in a volume on theories of rights, edited by Jeremy Waldron, and later discusses it in a chapter in The Morality of Freedom. So in both chapters, Raz criticizes right-centric theories, and the concept of an intrinsic duty is central to his critique. Raz's criticism in these chapters is similar to an argument that Rob and I advanced in a recent study of rights of nature laws that James has mentioned. So in that article, we argue that rights-based models are not well suited to advancing a green normative ethic. We found Raz's concept of intrinsic duties helpful in explaining our duty-based alternative to rights of nature and became interested in doing more work on this topic. So this current project has two objectives. First, we seek to clarify the concept of an intrinsic duty as a distinctive type of duty. Second, we seek to clarify the potential theoretical role of this concept in the legal context. And here we want to argue that intrinsic duties both can and should play an important role in theorizing legal obligations. In particular, we think that there are certain features of constitutional law that demonstrate the concept's potential explanatory power. Tentatively and more ambitiously, we think that understanding these features may in fact require intrinsic duties as an analytical concept. So my presentation will generally follow the outline of the circulated paper. The first part will focus on clarifying the concept of an intrinsic duty and distinguishing them from other kinds of duties. The second part will consider the theoretical benefit of this concept for analyzing legal duties, focusing on state duties in relation to constitutional goods. Now, before proceeding, let me say a few things very briefly about the scope of our analysis. First, it's important to emphasize that our aim is to clarify the concept of an intrinsic duty on its own terms. So we're trying to give the most plausible interpretation based on Raz's discussion in the chapters that I've mentioned. Importantly, however, we do not attempt to analyze how the concept aligns with other aspects of Raz's philosophical work over the course of his very long and productive career. The second preliminary point concerns the possible implications of our analysis for theories of rights. So it's not our aim to make any general contributions to debates about rights. At the same time, though, we do want to suggest that the concept holds general interest irrespective of one's preferred theory of rights. Now, Raz, of course, articulates the distinctiveness of intrinsic duties with reference to his own interest-based theory. But we think there's no reason, at least not in principle, why someone who's attracted to a different theory of rights couldn't make use of the concept. And this includes both will-based theories and hybrid theories, such as the type of theory defended by your colleague, Mark McBride. Okay, so with these preliminaries in mind, let's turn to the key conceptual question. What is an intrinsic duty? And what makes intrinsic duties different from other kinds of duties? So we identify two structural features that distinguish intrinsic duties. The first we call their distinctive justificatory structure, and the second we call their distinctive valuational structure. Both of these aspects are equally important. So let's start with the first feature. As I stated at the outset, intrinsic duties are a type of duty that is not derived from or justified by rights or by the interests of individuals. In this respect, they're distinguishable from duties that are typically thought to be correlatives of rights. So Raz gives two examples that are meant to illustrate this distinctive justificatory structure: duties to preserve great works of art and duties of friendship. Starting with the art example, Raz asks us to imagine that we own a Van Gogh painting. Suppose it's Girl in White. Is it wrongful to destroy the painting? Well, clearly, because I own the painting, no one has a right that I shall not destroy the painting. But many of us also have the intuition that we have a duty not to destroy it. Where does this duty come from? Raz suggests that the duty is derived not from anyone's interest in the painting, but from, quote, respect for values which give meaning to human life, of which he thinks art is a component. What about friendship? According to Raz, friendship itself is a relationship that's comprised of, quote, requirements, reasons for action that are intrinsic and not based on rights. One such requirement, he suggests, is a duty to make reparations for harm that we cause, irrespective of our fault. Why is that so? It's because friendship itself consists in duties to act out of concern for the friend. One way we express concern is by making reparations for harm that we cause. So here Raz concedes that our friend's well-being gives us a reason to act on their behalf, but he argues that it's the intrinsic value of the friendship itself that gives us a duty to act. Now, both of these examples are meant to capture an important intuitive judgment, namely that there are duties that exist apart from rights in the interests of individuals in certain goods, and that the interests of individuals in certain goods are insufficient to justify holding another under a duty to satisfy or protect those interests in that good. At the same time, though, we think these examples are also somewhat limited and potentially even a bit misleading. As we explain in the paper, we think that they serve to demystify rather than exemplify intrinsic duties. And that's because neither example adequately captures the second key structural feature of intrinsic duties, which we refer to as their valuational structure. So this aspect of intrinsic duties is a bit less straightforward for reasons that I will explain, but it's equally important. The valuational structure of intrinsic duties is what explains the precise sense in which they have intrinsic value. So this is best explained first through considering the context in which Raz introduces the concept, and second, through comparing intrinsic duties with adjacent concepts in moral philosophy. Okay, so let's start with the context, and that's going to be the main focus of my discussion. As I mentioned at the outset, Raz introduces the concept of intrinsic duties in support of a wider critique of right-centric accounts of morality. So Raz's critique has to do with the limitations of rights and accounting for duties associated with a particular class of goods, which he calls collective goods. And this relationship to collective goods is key. So what is a collective good? Generally speaking, they're goods, including relationships and states of affairs, that have intrinsic value in the following sense. First, their value is not derivable from the interest that individuals have in that good. And second, their value is constitutive rather than aggregative. They comprise or form the basis of ways of living or being that are valuable in themselves or have ultimate value according to some normative theory. Now, note that although Raz's focus is, of course, liberal humanism, this could potentially be any normative theory. So Raz provides several examples of collective goods that illustrate this non-derivative and constitutive sense of intrinsic value. These include self-governance, a beautiful and healthy environment, and a tolerant and culturally diverse society. So the value of these goods can't be reduced to the interest that particular individuals have in them. Instead, their value lies in comprising or forming the basis of ways of living or being that are valuable in themselves or have ultimate value according to liberal humanism. And that's because they provide the necessary conditions for well-being, which on Raz's view consists in the successful pursuit of valuable, willingly embraced goals. In other words, these are goods that make well-being possible. Now, Raz's central argument is that rights are not well equipped to account for the duties that we have to realize these collective goods. And there's two reasons that he gives for this. First, even though many and perhaps even most individuals benefit from collective goods, these benefits are often insufficient to justify rights. For example, as Raz points out, self-governance is an important collective good, but we generally don't think that individuals have rights to self-governance. But if there are no rights, then rights can't account for the duties to realize the collective good. So call this the no rights problem. Second, even where it does make sense to think of individual rights to collective goods, Raz insists that such rights are limited in explaining the value of collective goods. For example, it makes sense to talk about the right to vote as an aspect of self-governance, but interest in electoral participation can't explain the value of the collective good. So call this the distorting tendencies problem. Now, this point about distorting tendencies is particularly important. It's what provides a response to right-centric theorists who might be tempted to appeal to group rights to account for duties to realize collective goods. Raz doesn't think that this strategy fares any better because of the distortionary tendencies problem. So it's important to get clear about what the concern is. So what exactly is the nature of this concern? The problem is that rights focus on the interests that individuals or groups have in a good. But this focus on interest does not adequately capture the value of the good qua collective good. The value of collective goods does not lie, at least not exclusively, in satisfying interests, even extremely compelling interests, but rather in providing the necessary conditions for well-being. So collective goods should be realized irrespective of particular benefits. So for example, even if interests in electoral participation, such as voting, can account for the full range of state duties that exist in relation to self-governance, which seems a bit doubtful, these interests, however compelling, nevertheless fall short of explaining the value of self-governance. And the good of self-governance should be realized irrespective of particular interests in electoral participation. Raz's discussion in a later article, Liberating Duties, is also helpful here. So in this article, he makes the observation that rights are results-oriented and have a confrontational character. He suggests that this makes rights suited to context in which what primarily matters is how one person's actions affects the interests of another. But it also makes rights inappropriate in contexts where what matters is valuational attitudes. So for example, attitudes of respect, friendship, or love. So this discussion, we think, illuminates the unique function of intrinsic duties. So unlike duties that are derived from or justified by rights, they do not have the quality of fetters that exist to serve the interests of others in a good. Rather, intrinsic duties exist to serve the good itself. Thus understood, the duties of Sylvan's last man towards the natural environment, the example that we started out with, may in fact provide a better illustration of intrinsic duties than Raz's two intuitive examples. And that's because the last man's duties, called these ecocentric duties, better capture the distinctive valuational structure of intrinsic duties. So unlike art and friendship, ecological well-being is a collective good. It is not reducible to the interests that particular individuals or even particular species, whether human or non-human, have in the natural environment. And ecological well-being makes life itself possible, and life is valuable in itself, if not of ultimate value on any view of what is good. This suggests that, even on liberal humanist views, there are certain duties to realize ecological well-being that exist not to serve the interests of individuals or species, but that exist to serve ecological well-being itself. This argument for ecocentric duties as a type of intrinsic duty is, of course, even stronger if one rejects liberal humanism and regards ecosystems as entities that are worthy of moral concern in their own right, as Sylvan, of course, clearly did. Okay, so far we have seen that intrinsic duties not only have a distinctive justificatory structure, but also a distinctive valuational structure, which has to do with their relationship to collective goods. And as I will discuss in a moment, the valuational structure of intrinsic duties distinguishes them from other duties that are generally understood not to be derived from or justified by rights. But before we turn to that discussion, let me briefly clarify the sense in which intrinsic duties are intrinsic. So in asserting that certain duties in relation to a collective good are intrinsic, we mean that they have a relationship to value that is basic or fundamental, and which is not mediated by any relationship to individual interests. Importantly, this relationship to value is a separate question from the duty's relationship to the good that has value. That is, whether or not a duty is an intrinsic duty with respect to a good is a separate question from whether or not it forms part of the good. And in fact, we think that this is what Raz's two intuitive examples were meant to help illustrate. So what the friendship example illustrates is that some duties are internal to a collective good, and in this sense, constitutive of the good. So duties that are internal to a collective good are necessarily intrinsic duties. They're among the collective good's intrinsic properties. In these kinds of examples, the basic or fundamental relationship to value is straightforward. So the good has intrinsic value, and the duty is part of the good. But what about duties that are external to a collective good? So these duties don't form part of the good. Nevertheless, Raz thinks that at least some of these are intrinsic duties because they express the value of a good. And the duty to preserve great works of art is meant to be an example of this. So expressive intrinsic duties are a little bit trickier to explain. There are a couple different ways to go that we discuss in the paper, But for the purpose of this presentation, I don't want us to get too bogged down in the details, so I'll try to keep it as simple as possible. So the basic idea is that expressive intrinsic duties are a direct response to the value of a good. That is, they arise from the recognition of the good's value. In this way, they help support a wider set of social practices, including evaluative attitudes that make the good's value possible. So to recognize the value of a great work of art, such as Van Gogh's Girl in White, is at least in part to recognize a duty to preserve it. And recognizing a duty to preserve it is part of what makes art an aesthetic experience possible. If we didn't recognize these duties, then the social practices would break down and we wouldn't be able to talk about an object like a painting having value. So this is what we think Raz means when he suggests that a refusal to act to preserve a painting like Girl in White is, quote, to do violence to art and to show oneself blind to one of the values that gives life a meaning. Now, to be clear, we do not think that defending the concept of expressive intrinsic duties requires commitment to any particular account of the relationship between the duty and the values in question. The main claim that we want to defend is that intrinsic duties, whether they're internal and constitutive or external and expressive, have a basic and unmediated relationship to intrinsically valuable goods that does not require recognition of individual interests in realizing those goods. So in the case of intrinsic duties and what we take to be the core sense, namely those duties that are constitutive or expressive of collective goods, it is the unmediated nature of their relationship to the collective good that is most significant. They're either expressive of its value, supporting the normative practices in relation to the good, or else they're constitutive of the good, comprising its internal properties. Either way, they're part of what gives the good its value. Okay. So far, we've examined the two structural features of intrinsic duties, their distinctive justificatory structure and their distinctive valuational structure, which has to do with their relationship to collective goods. And I've just been arguing that this valuational structure explains the sense in which intrinsic duties have intrinsic value. Namely, they have a basic or fundamental relationship to the value of a collective good, which is not mediated by individual interests in that good. So this valuational structure also distinguishes intrinsic duties from adjacent concepts in moral philosophy. This includes imperfect duties, duties to oneself, and indirect duties. So we think comparison with these other duties is helpful in further clarifying the concept of intrinsic duties. But I should emphasize that in undertaking this comparison, we're not trying to provide a complete taxonomy of moral duties. Our much more limited aim is to try to capture some of the dimensions of intrinsic duties that we think make this concept particularly useful in the legal context, the topic that I will be turning to in the second part of my presentation. Now, I do want to make sure that I leave some time for that discussion, so I'm going to keep this part of my presentation very brief, just noting the key features that distinguish intrinsic duties from these other kinds of duties. Okay. So let's start with imperfect duties. So these are associated with Kantian ethical theory and have the following key features. First, they do not prescribe specific or concrete acts. Second, their fulfillment generally cannot be demanded. And third, failure of performance in specific cases is not blameworthy. As a result of these three features, imperfect duties can be fulfilled in many different ways, and there's a degree of discretion in both how and when they are fulfilled. However, there's also a sense in which talk of fulfillment is misleading. And this is illustrated by the two core examples of imperfect duties, which are duties of charity and duties of beneficence. Neither of these duties is ever really fulfilled. Instead, they function as wider normative constraints. And this aspect of imperfect duties strikes us as similar to intrinsic duties. Their relationship to collective goods suggests that they also often function as wider normative constraints. But there are several important differences which suggest that intrinsic duties are better suited for the legal context. First of all, intrinsic duties are capable of prescribing specific or concrete acts, and failure to act is blameworthy. Moreover, it strikes us as an open question whether the fulfillment of intrinsic duties can be demanded. Clearly, this cannot ordinarily be demanded as of right. However, there are at least some examples from constitutional law that demonstrate how performance can be demanded in other ways. And I'll mention this in the next part of my presentation. Finally, imperfect duties and intrinsic duties have a different orientation. So core examples of imperfect duties focus on benefits to other, and this gives them an interpersonal dimension, which suggests that they can support collective goods. However, within Kantian ethics, they are, strictly speaking, duties to oneself. This means that, unlike intrinsic duties, they're fundamentally oriented towards moral perfection or virtue, and not towards the realization of a collective good. Now, our second comparison, duties to oneself, can be dealt with very quickly. So these are analogous to imperfect duties. They too are fundamentally oriented towards moral perfection or virtue. However, core examples involve first-person benefits. Any benefits to others are at best incidental. So this self-benefiting character of duties to oneself makes them even further distinguishable from intrinsic duties than imperfect duties, which at least have a social or interpersonal dimension. Our third comparison is indirect duties, and these are duties that are derived from or justified by other duties. So like imperfect duties, this concept is associated with Kantian ethical theory, where it's used to account for duties towards non-rational others. On a Kantian view, there cannot be any direct duties to non-rational others because only rational beings have moral standing as ends in themselves. For this reason, indirect duties are widely used in Kantian environmental ethics to account for obligations towards animals and towards the natural world. So this derivative status of indirect duties importantly distinguishes them from intrinsic duties in at least two respects. First, although at least some indirect duties can be characterized as oriented towards the realization of a good, that good, at least on Kant's view, can never be a good with intrinsic value. Only direct duties that are owed to rational nature can have that status. Second, and more importantly, this derivative status means that indirect duties, insofar as they are duties towards goods, do not have a basic or fundamental relationship to the good's value. Indirect duties are only ever instrumentally justified insofar as they're required to respect persons. So Christine Korsgaard highlights this important limitation in her discussion of Kantian environmental ethics. In particular, Korsgaard observes that the derivative status of indirect duties means that they do not allow us to value animals for their own sake. In her view, that's a reason for rejecting an indirect duty view of animal ethics. Okay, so let me summarize where we've got to so far. So this concludes my discussion of the concept of intrinsic duties. So in summary, intrinsic duties are uniquely oriented towards the realization of collective goods. They exist to serve a collective good and not the interests of individuals in that good. And they have a basic and unmediated relationship to the good's value. So this distinguishes them from other duties and moral philosophy that are not justified by or derived from rights. In the second part of my presentation, I want to consider the application of intrinsic duties to the legal context. So recall, Raz's aim was to draw attention to certain features of morality that could not be explained by rights. But you might be wondering, why should legal theorists care about this? What's the relevance of intrinsic duties when it comes to the analysis of law and legal systems? So we argue that the concept of an intrinsic duty as a distinctive type of legal duty is particularly helpful and perhaps even necessary to capture certain features of constitutional law. In particular, we want to suggest that certain constitutional goods are best understood as collective goods in Raz's sense. And we also want to suggest that at least some duties in relation to these collective goods are best understood as intrinsic duties in the sense that they're not derivable from or justified by rights and exist to serve the good itself rather than the interests of individuals or groups in that good. So in developing this argument, there are three areas that we want to consider. And as you will see from the draft that was circulated, this part of the paper is incomplete. Now, these are all topics that are related to my own research in constitutional theory, which I have been thinking about over a number of years, and we can, perhaps discuss more when we have time after my presentation. So I'll try to provide a little bit more detail in my presentation than we've done in the paper, but I am also conscious of time. So in order to maximize opportunities for discussion, I'm just going to outline these very briefly, from the least ambitious to the most ambitious. Okay, first example. So many constitutional provisions are deliberately formulated as duties and are meant to provide alternatives to rights provisions. So we think intrinsic duties can help account for these duties-based alternatives. So a key example from my own research is directive principles of social policy. So directive principles require the state to realize particular goods, but they're not capable of direct judicial enforcement. Although, like imperfect duties, there's a degree of discretion in how directives are fulfilled, there are limits to this. It's not simply up to the state to decide. Moreover, failure to fulfill them is blameworthy. So states that do not take steps towards their realization are in breach of their constitutional obligations, and there are legal consequences for this, even though those consequences do not involve direct judicial enforcement. Finally, although fulfillment of directive principles cannot be demanded as of right, this can occur in other ways. For example, obligations that are created by implementing legislation can be enforced, and the adequacy of implementing legislation can be challenged. Second, we also think that intrinsic duties may better describe state duties in relation to constitutional goods that tend to defy individualistic analysis. These include cultural, linguistic, religious, and environmental goods. So these goods are often characterized as third-generation constitutional rights. According to at least some critics, however, the value of these goods is distorted by rights-based frameworks. And that's because their good is not explicable in terms of the interests that particular individuals have in them. So group rights are sometimes proposed as a workaround here, but it isn't always obvious that these do the trick for the kinds of reasons that Raz gives about distortionary tendencies. And in any event, there are other concerns about group rights, both conceptually, whether it's conceptually possible for groups to hold rights, and morally, so concerns about the effects of individuals, members of a group when group rights are recognized. So even if group rights don't necessarily raise distortionary concerns, intrinsic duties may provide an attractive alternative. Third, we think that the concept of intrinsic duties can help improve theoretical accounts of how courts reason about the scope of rights and limitations on rights in constitutional adjudication. We think this applies even in the case of many core civil and political rights, such as the right to vote or the right to free speech. This is the most ambitious argument because these kinds of constitutional goods generally can be analyzed in terms of individual interests, which justify concrete rights, which then generate correlative duties. However, beyond the specific duties owed in concrete cases, there are wider state obligations to guarantee or to progressively realize the relevant good as a collective good in Raz's sense. So, for example, the right to vote requires all of the machinery and institutions for free and fair elections. So voting is a kind of collective good. So we see this point as analogous to Raz's observations about liberal commitments to autonomy. Insofar as liberal theory assigns intrinsic value to autonomy, there are duties to promote an autonomous society. And yet, the nature of these duties is distorted if we think of them as duties that are derived from individual rights to an autonomous life. So we think these kinds of considerations, which of course regularly feature in judicial reasoning and constitutional rights adjudication, may be helpfully analyzed in terms of intrinsic duties. So I want to finish this discussion with a very concrete example, which is a recent decision by the Ontario Court of Appeal in Canada. This is the case Fair Voting BC and the Attorney General of Canada. So this case concerns a constitutional challenge to Canada's first past the post electoral system. So the primary basis for the challenge was that this method of selecting representatives infringes Section 3 of the Canadian Charter of Rights and Freedoms, which guarantees the right to vote. The court ultimately dismisses this challenge, holding that Section 3 does not guarantee the party's preferred system of proportional representation. Now, we don't have any views on the outcome of this case, but we do think that the court's reasoning illustrates why it is distorting to view the state's obligations with respect to a collective good like democratic representation exclusively through the lens of the right to vote and individual interests in electoral participation. So the appellant's argument, in effect, was that the Canadian electoral system itself violates an individual's Section 3 right to vote. But as Justice Huscroft points out in the lead judgment, this sounds odd. An individual's right to vote does not exist in the absence of an electoral system. Moreover, as Justice Daw points out in a concurring judgment, quote, the logic of the appellant's argument implies that every imaginable electoral system would violate the Section 3 charter rights of at least some voters. After all, every individual has an interest in electing their preferred candidate. At the same time, however, we also think that Justice Huscroft's response to the appellant's argument goes too far in asserting that Section 3 only protects an individual's right to vote in whatever electoral system happens to exist. The fact that the right to vote only exists in the context of an electoral system established by legislation and executive action does not mean that anything goes. So in our view, what both perspectives miss is that the issue is fundamentally one of state duties to realize a collective good. These are not duties that are justified by individual interests in electoral participation, but nor are they duties that escape constitutional scrutiny or blame because they're oriented towards perfection or virtue. They're duties that exist to serve democratic representation, which is a collective good. They are intrinsic duties. Focusing exclusively on the right to vote distorts the value of this good. As former Justice Iacobucci of the Supreme Court of Canada stated in a leading Section 3 case, quote, participation in the electoral process has an intrinsic value independent of its impact upon the actual outcome of elections. Now, to be clear, we do not mean to suggest that rights do not have a proper role to play here. Our point is rather that rights play a different role, which is protecting individual interests. And this is a very important role. Protecting interests in electoral participation is foundational to a functioning democracy. But this role is a limited one, and it's a different role than the role played by intrinsic duties. These different roles played by rights and duties derived from rights on the one hand, and intrinsic duties on the other hand, are in fact reflected in the two distinctive lines of Section 3 jurisprudence. As Justice Huscroft notes in his judgment, cases involving the denial of voting rights in the sense of exclusion from the franchise have a distinctive character from cases involving requirements of effective representation and meaningful participation. So we suggest that whereas the first set of cases are properly characterized in terms of the right to vote and their correlative duties, the second set of cases seem better characterized in terms of duties that exist to protect the institutions of democratic representation themselves. Okay, so to conclude. So in summary, I've argued that the concept of an intrinsic duty is best understood as a duty that has a basic or fundamental value of a collective good, which is not mediated by any relationship to individual interests in that good. Unlike duties that exist to serve the interests of individuals in a good, intrinsic duties exist to serve the good itself. They're either expressive of its value, supporting normative practices in relation to the good, or else are constitutive of the good, comprising its internal properties. For Raz, the concept of intrinsic duties supported a wider argument about the limitations of rights-centric theories in accounting for the normative structure of morality. The aim of our project is to show how it may also be helpful in accounting for certain kinds of legal duties, especially in the constitutional law context. Now, although the primary focus of this discussion has not been methodological, I want to conclude my presentation with a few general observations that go to wider issues concerning method in legal theory. So we suspect that one factor contributing to the neglect of the concept of intrinsic duties in the literature is that the context in which Raz introduces it has not been well understood. In particular, what little discussion that the concept has received tends to assume that the point is to provide a counterexample to Hofeldian right duty correlativity. But this is incorrect. Raz's central concern has to do with conceptual resources that are needed to make sense of the normative structure of morality. We think that this also betrays some limitations of Hofeldian methodology in both moral and legal philosophy. As others have observed, Hofeld mainly had his sights on private law. It would therefore not be surprising if his schema had less methodological relevance outside of legal relationships that are structured around a putatively bipolar relationship between plaintiff and defendant. This schema might be applicable to some kinds of normative relationships, such as the relationship between promisor and promisee, but it would be surprising if it provided the conceptual resources necessary to provide a complete understanding of the structure of our normative universe. Finally, I make the general observation that there seems to be far less concern in moral philosophy about duties that are not derived from or justified by rights, or indeed about prioritizing duties over rights. In contrast, there seems to be a prevailing assumption that law is predominantly right-based, and that the distinguishing feature of legal duties is that they're derived from rights. Although it has not been the central aim of our project to do so, we do think that our analysis of intrinsic duties casts some doubt on this assumption. Nevertheless, while our account of intrinsic duties may have implications for wider debates about rights, we're ultimately concerned with the theoretical benefit of this concept when it comes to accounting for particular features of law and legal systems. Concepts and principles are the building block for theories, and intrinsic duties are just that. They're one building block among others that may be more or less useful depending on one's theoretical aims. Thank you very much.